Welcome to the Legal Masterminds podcast. This is where sharp minds meet sharp law. We break down landmark cases, teach strategy, and keep you steps ahead. Whether you are a lawyer, law student, legal intern, or just someone who loves smart conversations. Inside this podcast, we do not just talk law, we unlock it. Want to join the community behind this podcast? Send us a DM. We promise you will love it here. Now let us get into today's case.
This is a summary of Ubabuike v Guaranty Trust Bank Plc and Barrister Chris Atiboka, a decision of the Supreme Court of Nigeria delivered on the 14th of February, 2025. The judgment was unanimous. The panel comprised Justices Gabra, Abubakar, Sankey, Yowa, and Tuka, with Justice Gabra delivering the lead judgment. The dispute began in 2009 when Patrick Ubabuike, a customer of Guaranty Trust Bank, secured a loan of 10 million naira. Before repaying the loan, he filed an action against the bank and its lawyer, alleging that the mortgage used to secure the loan was tainted by fraud. The High Court of Plateau State struck out the case, describing the writ of summons as incompetent. The court nevertheless proceeded to evaluate the merits of the claim and ruled against Ubabuike. Dissatisfied, Ubabuike approached the Court of Appeal. There, he filed 8 grounds of appeal but framed 13 issues for determination. Crucially, his brief failed to indicate how each issue related to the grounds of appeal. The Court of Appeal held that this is a serious procedural error and struck out the entire appeal. According to the Court of Appeal, parties must not generate more issues than there are grounds. Furthermore, briefs must clearly link each issue to its supporting ground. Courts are not permitted to speculate or guess the connection between grounds and issues. However, the procedural flaws in the appeal went deeper. One of the justices listed as concurring in the Court of Appeal's decision, Justice Onyanji, had not been part of the panel that heard the appeal. He wrote a concurring judgment in a matter he had not participated in. This breached Section 294, subsection 2 of the Constitution of the Federal Republic of Nigeria. That provision is clear: only justices who heard a matter may deliver or participate in its judgment. The Supreme Court held that this was not a minor procedural irregularity, but a jurisdictional defect. Justice Gabra stated that a judgment delivered by a panel that was not properly constituted is void. Once this constitutional requirement is breached, as in this case, the Supreme Court lacks jurisdiction to proceed. Jurisdiction cannot be assumed or conferred by consent, and no argument or conduct by the parties can cure a defect of this nature. On the issue of the 13 issues raised from only 8 grounds, Justice Sankey reaffirmed the settled principle that such proliferation renders the brief incompetent. Each issue must derive logically from at least one ground. Multiplying issues from a single ground creates confusion and violates settled appellate standards. The Court of Appeal was right to strike out the brief on that basis alone. The appeal, in substance and in form, was defective. Justice Yowa addressed another vital point. Even when a court finds that an appeal is procedurally defective, it has a duty to address the merits of the case, especially if it is an intermediate appellate court. The Court of Appeal failed to do so. However, in the Supreme Court's view, that failure did not occasion a miscarriage of justice. Since the Court of Appeal's judgment was void ab initio, the oversight made no legal difference. Justice Abubakar then clarified that the Supreme Court acted suo motu in raising the jurisdictional issue. That power is well established. Courts have a constitutional duty to examine jurisdiction at all times. Where jurisdiction is lacking, the proceeding is void, and the court must strike it out whether or not the parties raise the issue. Justice Tuka also addressed Ubabuike's claim that he was denied a fair hearing. That argument was rejected. His brief was poorly constructed, procedurally defective, and failed to comply with the rules. A party who flouts the rules cannot turn around to accuse the court of injustice. There was no breach of fair hearing. Instead, there was a failure of legal craftsmanship. The blame lay squarely with the appellant. The Supreme Court also sounded a broader warning. When a judge who did not participate in the hearing delivers or signs a judgment, the decision is incurably defective. This is not a technicality. It goes to the very root of judicial power. A judgment must reflect the deliberation of the judges who actually heard the case. Anything else is a constitutional violation. For legal practitioners, this case reinforces several key principles. First, a ground of appeal must support at least one issue, but one ground cannot support multiple unrelated issues. Second, every issue in a brief must clearly identify the ground from which it arises. Third, judges who did not sit on an appeal must not participate in the judgment. Fourth, the Supreme Court has the power to raise and decide jurisdictional questions even without prompting. Fifth, fair hearing cannot be claimed by a party who causes the procedural failure. The appeal was dismissed. But more importantly, the judgment is a call for procedural discipline. Lawyers must write precise, well-structured briefs. Judges must uphold constitutional safeguards. An appellate practice must never become casual or careless. The law is strict, and the process is just as important as the outcome.
Hope you enjoyed this case. Now imagine having access to minds that break down the law like this every single week. Why not join our Legal Masterminds community today? We do more than analyze cases. We build legal giants. One thing we promise you, you will stay up to date with Nigerian law, master powerful legal strategies, and connect with people who think just like you. Our next meeting is this coming Saturday at 8 p.m. West African time. We are always prompt, no delays. Send us a DM to join. The seat is yours if you are ready. Till next time, stay learning, stay bold, stay sharp.